Hello, my name is Richard Albert, and I'm here today with Mike Powell, Assistant Professor at the University of Ottawa, and also a Fellow at the Mowat Center at the University of Toronto. And today, Mike is joining us to talk about the constitutional politics of election law in Canada. Mike, hi, thanks so much.
Thanks so much for having me, Richard. It's a pleasure.
Mike, you're at a great place at the University of Ottawa. You have a very active public law group, this bilingual, bi-jural jurisdiction. Great place to be a comparativist, isn't it?
Fantastic. I think we've got the largest group of public law scholars in the country, and Ottawa is a great place to do public law with courts and Parliament here. So I just started in July, and I'm loving it.
Well, congratulations. Before we talk about our subject for today, which is the constitutional politics of election law in Canada, I want to ask your thoughts about Canada's newest Supreme Court Justice, Suzanne Cote, whose appointment to the court is effective December 1st. What do you know about her, and how is she regarded?
Right, so Justice Cote comes with impeccable credentials. She was the head of the litigation group at a prominent law firm, Osler's in Montreal, and had served as commission counsel to the Bastarache inquiry onto judicial appointments in Quebec, very prestigious, and then also at the Justice Laurie Douglas inquiry at the Canadian Judicial Council. So she could not have a better reputation at the bar. She is the first woman to be appointed directly from practice. There had previously been two male justices who had that distinction. And she brings the complement of women on the court up to 4 out of 9 justices, so restoring some gender balance that had been lost. So the big question mark for her is not credentials or capacity, but because she comes straight from practice, we don't know what her judicial ideology is. We don't know what her political ideology is. We don't have that track record of trial or appellate decisions in criminal law or public law or civil law procedure or any other area.
So it remains to be seen. But thanks for that update. I thought it was appropriate to ask you since this appointment is fresh. It's hot off the press. There has, however, been some controversy surrounding her appointment, correct? Could you maybe fill us in on that context?
Right. So there's been a lot of scrutiny about the appointment of Justice Cote, primarily because of what came before. And the background is the Canadian Supreme Court of 9 members has 3 seats reserved for the province of Quebec. And the federal government had recently attempted to appoint a judge named Justice Marc Nadon, who was on the federal courts. Now, Justice Nadon was supposed to fill one of the 3 Quebec seats and went so far as to be sworn in, answered questions in front of a Parliament committee, and then was actually sworn in. The controversy arose in 2 respects. One, Justice Nadon was the subject of an unprecedented, I would say, level of public criticism for his qualifications. So he was referred to in the media as a semi-retired judge, which I don't think was actually accurate, but he was what we would call supernumerary, so he had a reduced caseload. And he was well known as a maritime law specialist, which is not a significant portion of the Supreme Court's docket, and for a very pro-government and strongly worded dissent in the case of Omar Khadr, who's kind of an infamous Canadian imprisoned at Guantanamo for actions he committed as a child. So there were questions raised about Justice Nadon's merits as a judge, which had not previously been what any appointee had been criticized for. A constitutional challenge was then brought saying Justice Nadon was not actually even eligible. That to be a member of the Supreme Court from Quebec, you had to meet specific requirements, namely to be a member of the Bar of Quebec of 10-year standing, or a judge from the Quebec courts. And Justice Nadon was a member of the federal court, not of the Quebec courts, and the argument went that he was ineligible. And a reference eventually was made to the Supreme Court of Canada, and the Supreme Court held that as a member of the federal court, Justice Nadon was in fact not eligible. And because he was not from the Quebec courts, there was a strongly worded dissent from my old boss, Justice Moldaver, saying this was a very technical reading of the statute. But the Supreme Court found he was ineligible, and then we even went further and said to change the Act and to change the rules of eligibility because the appointment procedures in the Supreme Court Act, or what was understood to be a regular piece of legislation with a lot of importance, but a regular piece of legislation. And the Supreme Court said you actually need the consent of the provinces for the federal government to change the legislation under the amending procedure for the Constitution of Canada. So the Supreme Court Act got brought in to the Constitution, which was also controversial. So, and then just to conclude, there were also some other public disputes where the Chief Justice was accused by the Minister of Justice of inappropriately discussing the eligibility of Justice Nadal before it had come to the court. And then the Minister of Justice criticized members of the parliamentary committee that had been part of the process for the appointment for leaking information to the Globe and Mail newspaper. So kind of unprecedented level of discussion about eligibility, qualifications, and the process.
And so this is all the backdrop to Justice Cote's appointment.
Right. So then Justice Cote was appointed as a matter of executive discretion with no public consultation and very little by way of process that was available for the public to evaluate.
And so how has the process of appointments to the Supreme Court, how has that evolved over the years? Is this normal? The way you described it suggests that it's not normal. You described it as a kind of unprecedented level of executive discretion without consultation. What is the normal course of things in terms of judicial appointments?
Right. So throughout Canadian history, the normal course has been that the executive, meaning the Prime Minister and the Cabinet, appoint the justices with very little scrutiny and no public process. But then in the 2000s, there was a move across all parties to bring greater transparency and predictability into the process. So the Paul Martin government in the early 2000s introduced, they publicly produced the criteria for an appointment. They brought in an advisory committee of eminent Canadians and members of the legal community. They standardized who was to be consulted. Right? There were consultations that informally happened beforehand, but we couldn't see who was consulted and whether that was done in a fair way. And they brought in a parliamentary committee that would ask questions of the Justice Minister, not of the appointee, but of the Minister of Justice, who was the cabinet member most responsible. The Harper government actually expanded on this in a way by introducing questioning by the parliamentary committee of the appointee, right? So of the judge, the future judge of the Supreme Court of Canada. Eventually, the process was changed slightly by the Harper government so that the committee, which had been an all-party committee, still was an all-party committee, but with a majority of Conservative members, ended up eventually doing a lot of its meeting behind closed doors, hence the criticism of the leak about the members. So Justice Nadal was a member of a shortlist produced by the committee, an unranked shortlist that went to the Minister of Justice. After the controversy with Mr. Nadal, Justice Nadal, the government actually retrenched, and the process went into a period of devolution. So actually, the public consultation was taken away. The public process, the public standards, public criteria were all eliminated. So Parliament had no role, the public had no role, and we can't say what role other governments or the members of the legal community had in the appointment of Justice Cote, and also her judge who was appointed just prior, Justice Clément Gascon.
So I suspect we haven't heard the last of criticisms of the judicial appointment process in Canada.
Right, so the former Minister of Justice who brought in a lot of the reforms, Irwin Cotler, who's a Liberal, has criticized the current Minister, Peter MacKay, saying Mr. MacKay, as a member of various committees, was all in favor of transparency and an improved process, and that isn't what the Harper government has followed for the last two appointments. So I think there was a real reason why reform started happening in the early 2000s, and that was because the process was so unsatisfactory. As many, especially political scientists, have pointed out, Peter Russell and others, Jacob Ziegel, over the years. So I think there are going to be renewed calls now that we've seen a slightly improved process. It had its flaws, but we're going to see renewed calls for some kind of a public, transparent, and if not accountable, at least a process that happens on public display.
Sure, and I'm sure we'll be hearing from you your commentary on that evolution as it happens. So election law. Election law, Mike, is a really hot topic right now in Canada, isn't it? It hasn't always been that way, but it is now. And why is that?
Right. So I was at a conference not too long ago where someone described the obscure area of private law that they were working in as toiling in dark obscurity over the years. So election law wasn't quite that in Canada, at least. But unlike the U.S., where after Bush v. Gore, there's been a real focus on election law, it hadn't quite been the same in Canada until quite recently. And I think there's a number of interesting reasons for that. One is simply that election law has gotten more complex. So elections are highly regulated environments now, and that wasn't the case prior to, I would say, the 1970s. And even since the year 2000, a lot of amendments have happened to the Elections Act. So there are now many more disputed election claims, or at least more prominent ones, and enforcement is happening at a different rate. So recently, the Prime Minister's former parliamentary secretary, Dean Del Mastro, was convicted for overspending, violating the spending limit in a recent election, and resigned his seat in the House as a consequence. So it's simply a more complex regulatory environment, which leads to more legal disputes and controversies. I think the second point has to do with the nature of politics. So I think similar to the U.S. and other established democracies, we have what a lot of political scientists have called a permanent campaign. So there isn't really a distinction between governing and campaigning, and there's a kind of continual search for partisan advantage. And how can you make it easier to win the next election? Sometimes it's not by putting forward attractive policies, but it's by gaming the rules of the electoral game, right? So sometimes that means passing partisan-minded election laws. We don't have gerrymandering in Canada, but there can be all sorts of other kind of partisan-minded election laws, or also simply trying to evade the election laws that are on the books. So the robocall scandal in Canada is an example where various conservative candidates were accused of sending out vote-suppressing automated calls that directed supporters of other political parties to the wrong polling location or on the wrong date, and purported to be from Elections Canada, but were not. So a lot of controversy around that. So I think that the political environment has contributed to the prominence of election law. And then just quickly, I'd add one more, which is in Canada, we've traditionally had very weak enforcement of election law. So Dean Del Mastro was punished, and then Michael Sona, conservative campaign operator, has now gone to jail for violating the Elections Act in the robocalls case in a riding in Guelph, Ontario. But he's the first person ever convicted under the voter suppression rules. And there's a long history of other types of cases where people were found to have violated the act but paid a very minimal penalty. So there's a case called the In and Out case, colloquially, that involved overspending by the Conservative Party by about $1 million, which is actually a lot in Canadian terms. Doesn't sound like a lot to American ears, but a lot in Canadian terms in the 2008 election. And the punishment for them was a $50,000 fine. So cost of doing business, $50,000 fine, had no impact on the party, and they were actually able to spend $1 million extra in an election campaign. So it's created the wrong kind of incentives where if you violate the law, you may not get caught, and even if you do, it's going to be a slap on the wrist. So that's another reason why parties and candidates are pushing the envelope, which leads then to more legal disputes.
So there's greater enforcement. I wonder about the role of courts in Canada. If we look around the world, we've seen courts take an increasingly active role in policing the electoral process. You mentioned Bush versus Gore, of course, the case that settled the electoral dispute between Al Gore and George W. Bush. We could also mention Turkey, where the Constitutional Court there has actually banned political parties from participating in the electoral process. I wonder, what has been the modern role of the Canadian Supreme Court in the electoral process? Anything amounting to anything close to what we saw in Bush versus Gore or what we saw in the Refa case in Turkey?
Right. So I wouldn't say that Canada's had a Bush v. Gore moment, right? Who is leading the government has never hinged on specifically what the Supreme Court has done. But the court has been very active in policing who has access to the ballot box, first of all. So the most famous case is called Sauvé, which gave to prisoners the right to vote, which they'd previously been denied. So the contrast is with the United States, Richardson and Ramirez, right, it allowed disenfranchisement. But Canada, the reasoning in the Soviet case was very similar to that in Hearst case, the European Court of Human Rights involving UK ban on prisoner voting, and some cases in South Africa. The Necro is one of the cases. So the court has very expansively defined who has access to the ballot box, kind of in reaction to the slightly shameful and not that well-known Canadian history of disenfranchisement of religious and racial and Aboriginal minorities. So that's the first thing. It's very taking an aggressive model in striking down government rules that hinder who can actually vote. Where it's had a really big impact, and I think comparatively has been a bit of a model for other countries, is in going beyond the ballot box. So the right to vote, it simply says you have the right to vote and to be a candidate in the Charter of Rights and Freedoms, but the court's read into that protections on a level playing field in elections. So the rationale that was specifically rejected by the U.S. Supreme Court and Citizens United, right, that you can't restrict political speech to have a level playing field, the Supreme Court of Canada actually adopted. So it said in a case called Harper that it's actually okay to very severely limit how much interest groups can spend in an election campaign. The number was $150,000 nationally, so really kind of small potatoes, especially compared to what's spent in the U.S. by interest groups. And it upheld those restrictions. So a very vigorous dissent in that case by Chief Justice McLaughlin said this actually amounts to a virtual monopoly on political participation during a campaign for political parties, if interest groups can only have a very small role. But that's the law as it stands today, and it's actually used also as rationale to uphold spending limits for political parties and candidates, not just interest groups. So the Canadian court's been quite influential there, and obviously in setting the agenda in Canada, but also internationally. And then third, just very, in a very small way compared to Bush v. Gore, but the Supreme Court of Canada is now getting involved in resolving disputed elections. So the robocalls case was not appealed to the Supreme Court, but there's a case called Opitz, which called on the Supreme Court to resolve a disputed election in the Toronto area about irregularities with the Elections Act. And the court really, I think, reacted to Bush v. Gore there and said, the last thing we want to be doing is resolving disputed elections. So they actually said, it's okay for the Elections Act to be violated in how the election's administered, as long as it didn't have basically an impact on the result of the election. So the Supreme Court's trying to take a hands-off on disputed elections. It really wasn't a Bush v. Gore moment in Opitz, but we'll see in the future if people try to bring similar types of cases.
It's really fascinating, Mike. I wonder if I can ask your thoughts specifically about the Harper case that you mentioned. And I'd love to maybe raise a contrast with the Citizens United case that you mentioned as well, and McCutcheon, its successor case. I've been reading a bit about this, and some scholars have suggested that the different rules on campaign finance, as between the U.S. and Canada, reflect different values in both countries. So whereas the campaign finance laws in the U.S. reflect a more libertarian approach to expression, in Canada it's more of an egalitarian value and approach to expression. Do you think that's fair? Is there something you want to add to that or refine that in some way?
Right. No, I think that's a fair characterization writ large. Now, whether there's a difference in the values of the of the country, right, or whether it's simply the policy decisions of the courts is kind of a different issue. I think Colin Feasby in Canada has written most in detail about how Canada adopted an egalitarian model in Harper, and then also an earlier case called Libman involving referenda. And it's definitely fair. I mean, the amount of money that's spent in American politics is so much larger than in Canadian politics, right? Even if there were no limits on campaign spending or interest group spending in Canada, the numbers would be nothing like they are in the U.S. But in Canada, many of the restrictions on interest group spending were struck down by the lower courts before the Harper case. And in an election in 1988 called the free trade election, on free trade between Canada and the U.S. was the main issue. Business groups in particular spent huge amounts of money. So the court definitely adopted an egalitarian rationale in Harper, but whether that's a kind of enduring, well, that's going to be an enduring judicial or policy consensus is a matter of debate, I think, because the earlier cases were hostile to that point of view. and political practice, I think, would evolve quickly to have interest group spending. So where this issue will come up again in Canada, and it'll test the limits of the egalitarian model, are in spending before the election period. So currently, spending during the election period is regulated very heavily with no restrictions outside of the period. But as a result, political parties now spend lots of money on advertising before the election even happens. So the Conservative Party ran ads against Liberal leader Michael Ignatieff saying he's just visiting, he didn't come home for you, and which were quite famous in Canada, and derogatory negative ads about Stéphane Dion, who was a previous Liberal leader, mainly before the writ was dropped before the election period. So I think there will be a movement if the government changes to potentially try to regulate what happens outside of the 36-day campaign period. And that'll test whether the Supreme Court is really committed to the egalitarian model or not. Because it's a much larger restriction on political speech and spending to have a yearly restriction or a 6-month restriction or something like that.
Oh yes, yes. I think that's fascinating. We'll wait and see what happens there. So there is a big case coming up in Canada, isn't there? Frank versus Canada. Now this case won't be argued yet at the Supreme Court, but rather at the Ontario Court of Appeal. Now, why is this such a big case, Frank versus Canada?
Right. So Frank's a big case because it really tests what are the limits of the Sauvé decision on prisoners voting, where the court really, if you read the reasons carefully, it's hard to envision almost any limit on the ability to cast a ballot. But one of the limits that remained was on voters Canadian citizens who resided outside of the country for more than 5 years. So if you're a Canadian and you live and you work in New York, you're still allowed to vote. But then once you've been there for more than 5 years, you're no longer allowed to. And that's a provision of the Canada Elections Act. So the trial level decision in the Frank case struck down that rule as unconstitutional for violating the right to vote in Section 3, basically applying the reasoning in Sauvé. What's the legitimate reason for preventing someone who wants to vote from voting? And it's hard to come up with a satisfying rationale for that, especially in the internet age when people have a lot of political information. Because you live overseas doesn't mean that you're denied information about Canada or you don't have a connection to the country. And especially given how mobile Canada's workforce is. There are many, many Canadians working in London and New York and Australia and in Asia. So the Frank decision was particularly notable because the judge in that case said there are no internal limits to the right to vote. The government had argued residency and by extension age, which are common restrictions on the right to vote through statute. Those are not actually part of the right itself, and any justification, any limitation of the right has to be justified under Section 1 of the Charter, the Oakes test for proportional balancing, which in the election law context has at times, not always, but at times been interpreted in a way that's very hard for the government to meet, and particularly in the Sauvé case for access to the ballot box itself, a very, very high bar for the court to meet, or for the government to meet. So Frank's a very significant case because if the Ontario Court of Appeal rules differently, and that residence is actually part of the right to vote, or that the limitations were justified, that opens the door for restricting the right to vote in the future in ways that were not imaginable after the Sauvé case. And the current government has shown, as I think we may discuss with the Fair Elections Act, shown a willingness to restrict who can actually go and cast a ballot, and could take advantage of a ruling that allowed them to restrict the right to vote on the basis of residency.
Well, let's move to the Fair Elections Act. You've just mentioned it. I'd like to ask you in a moment whether you think there are any constitutional infirmities with law. But before we get to that, what is this Fair Elections Act about? Why has it drawn just so much criticism from scholars, from observers, from politicians? What's the law about?
Right. So I made a joke before about election law being an area of quiet desperation for researchers, right, working in the dark. The Globe and Mail, the leading newspaper in Canada, wrote, I think, 3 or 4 editorials in a row about the Fair Elections Act, so about technical amendments to the Elections Act. And there was an unprecedented level of criticism from international and Canadian academics. And that was because the content of the law was, some of it technical, but some of it extremely egregious, I would say, if you value a fair and impartial democratic process. So the main problems with the law are that it undermines the independent, nonpartisan election commission, Elections Canada, and it makes it harder for many marginalized Canadian voters to cast a ballot. So some of the worst parts of the legislation were cut out, were amended out at the committee stage after this criticism. So there was a huge loophole in terms of campaign spending that was taken out in particular. And the government had proposed expanding the use of partisan appointees at polls on voting day. So those two didn't make it in. But there were still a couple of provisions that are now in law that are very troubling. So the government moved the investigation arm, the Commissioner of Elections Canada. So if you violate the Elections Act, that's who would investigate you and recommend prosecution. Move that office out of Elections Canada and under the authority of the Director of Public Prosecutions. Now, the Director of Public Prosecutions is relatively independent as far as members, as people who serve in civil service are, but still reports to a cabinet minister. And the questions whether Canada already probably had a too lax a record in investigating election law breaches, and the question is that going to improve under the new regime? It seems hard to imagine. All that remains to be seen. The Fair Elections Act also effectively muzzles the Chief Electoral Officer. So it restricts what the Chief Electoral Officer can do in public. So it'll be much harder for him to conduct voter outreach campaigns. And then in terms of actual access to the ballot box, the legislation restricted the ability, restricted the practice of vouching. So if you weren't able to prove your identification or residence, Canadian election law allowed another voter to vouch for you, usually your spouse, right? If you don't have a driver's license, you don't have bills in your name, especially for the elderly, your spouse would vouch that you are who you say you are and where you live. And the government restricted vouching. You can't vouch for someone's ID now. You can simply attest to where they live, their residence, and banned the use of something called the voter information card, which Elections Canada specifically produced to help those people without ID. So Elections Canada had allowed the voter information card to be used to prove your ID and residence. The government's now gotten rid of that. Those are all potentially problematic elements of the bill, rather now of the legislation. Excuse me.
Yeah. So the Fair Elections Law, it was passed into law over the summer. So it is now law. And I wonder, Mike, are there any constitutional challenges underway against the law?
Right. So. The Council of Canadians, which brought the challenge in the robocalls case, has said they will bring a challenge. I don't believe it's been filed yet. And they're specifically going to challenge two parts of the legislation. One is the rules on vouching, the more restrictive practice of vouching, and on the voter information card. So they're going to argue this is discriminatory against students. So there's been a report by a former Chief Electoral Officer of British Columbia that changing the vouching rules, that vouching actually helped seniors, Aboriginal people, students, and the poor and new Canadians, new citizens, because they didn't always have the proper ID. So the Council of Canadians, I believe, will be arguing that students who move often, who may not have a driver's license, which is the best form of, the easiest form of ID to use, may not have access to that, and that's unconstitutional under the right to vote or their equality rights. And then perhaps more speculatively, they're going after the government's muzzling of what the Chief Electoral Officer can say in public. So they'll try to argue that is counter to the idea of a fair democratic process. So that challenge is likely to be filed, and we'll, all of us, I think, in the election law community here watch very closely what will happen in that case.
It's interesting to take note of the continuities and discontinuities as between the U.S. and Canada on these issues. You mentioned voter identification and eligibility in your most recent answer about the Fair Elections Act. You read U.S. case law, you follow the recent case law about voter eligibility and identification in the U.S. Are there any lessons that Canada can draw from the U.S. experience on these questions?
Right. I think there's a lot Canada can learn from the U.S., good and bad. Right. So, you know, courts in Texas and Wisconsin have struck down voter identification rules that were overly restrictive. But famously, the U.S. Supreme Court in the Crawford and Marion County Board of Elections case allowed the Indiana voter ID law to stand. So the challenge in the U.S. and I think also for Canada is, how do you react to a law that has partisan motivations and partisan effects? The courts are very reluctant to look at the partisan political consequences of a law, but I would argue they are forced to do so in dealing with voter identification laws or rules on who can cast a ballot, like vouching and the Fair Elections Act. So Canada, we had a case called Henry, where in 2007 the current government introduced the first rules on photo ID, and those were challenged constitutionally for unfairly depriving the homeless of the right to vote. And the government relied on that case on the practice of vouching to say even if it's going to be harder for certain individuals to vote, you can still be vouched for. And that's enough of a safeguard, and the court bought that argument. But then the government tried to take away vouching, which in the original version of the Fair Elections Act, they ended up just restricting it, but they've made it now harder and harder to vote. And the question is why? So just like in the US, there is no evidence of wide-scale or even specific election fraud that would has ever changed the result of an election in modern times, right? So probably the least efficient way you could actually try to rig an election is to have in-person voter fraud where everybody brought a fraudulent ID or lied about who they were or where they lived. It's very easy to get caught, and it's very resource intensive. So the challenge for the Canadian courts, like the US courts, is what to do when you have a law, and it's very difficult to find a justification for it, but it looks like a trivial or technical change to the election law or election administration procedures. But the key is getting them to recognize it has an impact on discrete and insular minorities, if you can put it that way. I think the Texas and the Wisconsin courts recognize, but maybe not, well, the Supreme Court in Crawford did not. So we have no equivalent of the Voting Rights Act here to protect minority voters. So we might have to have a conversation learning from the U.S. experience about whether that's necessary, understanding that recent parts of that have been struck down, Shelby Counter and Holder and other related cases haven't necessarily expanded the VRA, but that might be something Canada needs to look at. Is there be some kind of an equivalent here?
I wonder, Mike, how often does the Canadian Supreme Court reference decisions of the U.S. Supreme Court, not to draw continuities or comparisons, but rather to raise sharp contrasts between the two constitutional cultures in Canada and the U.S.?
Right. I think generally in constitutional law, the U.S. is a natural comparator. The Charter of Rights and Freedoms has a lot of different content than the U.S. Constitution, but was clearly drafted in reaction to it in a number of ways. So having the right to vote as an explicit provision, and one of the number 3 in the Charter was, I think, in some ways a reaction to the U.S. experience without such an explicit guarantee of the right to vote. On election law cases, the U.S. is always running. So in Harper, it was before Citizens United, but definitely reference was made to the more libertarian regime in the U.S., especially in the academic commentary, but also by the court. And then notably in the Supreme Court's leading case on electoral boundaries, on one person, one vote, where the court actually said in 1991, Canada doesn't have the right to one person, one vote, much to the chagrin of people like me, but that is the rule in Canada, and the contrast was drawn with the U.S. The U.S. is strict, especially in congressional elections, strict one person, one vote rule, and there was an argument made by the Supreme Court, I think not a very convincing one, but an argument made on the basis of different political histories, accepting deviations from what we would call representation by population here. I think interestingly, especially for comparative audience, hopefully for this video, Australia is probably the country that comes up the most often in election law constitutional cases. And the Australian High Court cites Canada all the time. Happened with the Sauvé and the Roach case in Australia on prisoners voting, our Harper case and some of their related cases, and the Saskatchewan boundaries reference, and then the McKinley and McGuinty cases in Australia on electoral boundaries, all referring to each other very frequently. So there's a great comparative constitutional law paper on the migration of constitutional ideas, I think, between Canada and the U.S. and Canada and Australia on election law.
Oh, I see. Well, maybe we'll read some more references to the U.S. and Australia in future cases of the Supreme Court on election law. It seems very, very likely, if only to raise contrast between the two or 3 constitutional cultures. Mike, this has been really, really fascinating. Thank you so much. But before we go, I'd love to learn a bit about what you're working on right now, and also how you got interested in comparative public law. So first, what are you working on these days?
Right, so what I'm spending a lot of my time on now is on what we call electoral management bodies. So like Elections Canada or Elections Australia or equivalent bodies in the UK, these are independent, nonpartisan bodies that regulate the democratic process. But Some other constitutions, newer constitutions like South Africa's, and then some slightly older ones like India's, actually constitutionalize election administration. So they put these commissions in the Constitution, their existence, their powers, and usually their nonpartisan independent status. A lot of Latin American democracies do the same. Canada, Australia, US and UK, these are creations of their commissions, are creations of statute. And a lot of the disputes we've seen in Canada and elsewhere involve governments that have are constant conflict with election commissions who are opposing their changes to election law or their interpretation of election law or their campaigning practices. So a common theme is trying to undermine the independence of the election commission or to try to capture it, to use a kind of administrative law or regulatory language. So a lot of my work now is on how to protect the independence and impartiality of election commissions and asking questions about constitutional drafting and constitutional interpretation. Should we view electoral management bodies as a fourth branch of government, kind of questions often raised with the administrative state, but specifically with electoral management bodies? Or should we read into protections for the right to vote, a right to an impartial election administration, which is something that, say, the Canadian courts, for example, haven't grasped onto, but if the Fair Elections Act is challenged as we expect, that's something that will, if not explicitly be there in the debate, will always be in the background.
Very interesting. You're dealing with questions of constitutional, institutional design, how to create independence, create, sustain, and defend independence. Really, really fascinating.
Right. And what's the right thing to be in the Constitution, and what can be done by a statute, and really how much can we trust the political process to police itself, right? And what do we need to put beyond the reach of political majorities? And it may be that election administration is one of those things. And you also asked how I got into it. I have a background in comparative political science and worked in politics on and off for a few years, so saw how electoral law, election rules shaped how politics happened, and naturally had a comparative lens for my background in political science. So that's how I got into it. As an intern on Parliament Hill in a nonpartisan program from the Canadian Political Science Association, I worked with an MP in the committee that was involved in Canadian electoral boundaries and changing the boundaries. So that's kind of spurred me to get interested in election law and comparative focus.
Oh, well, that's great. So there is a reason why you were drawn to this field. Maybe a bit of happenstance, a bit of good timing. Fantastic. Well, Mike, thank you very much for joining us today to fill us in on what's going on in Canada and helping us think about the constitutional politics of election law in Canada. Thank you so much.
It's been my pleasure. This is a fantastic series and great work you do with the YCC and American Society, so it's a real pleasure.
Thanks a lot, Mike.
Okay, take care.
Bye.